Law school teaches you to think like a lawyer. It doesn't teach you to think like a good one. The difference matters more than you realize. Thinking like a lawyer means spotting issues and applying rules. Thinking like a veteran lawyer means seeing the bigger picture, understanding what actually matters, and knowing how to get from problem to solution without wasting time or your client's money. Nobody's going to teach you this shift. But you can start building these instincts now, before you're 3 months into your first job and drowning. Clients don't come to you with legal problems. They come with business problems that happen to have legal dimensions. Your job isn't to identify every conceivable legal issue. It's to solve the actual problem your client faces. Instead of starting with, what are all the legal issues here, start with, what is my client trying to accomplish and what's standing in their way? A client doesn't care that you've spotted 17 potential claims if none of them get what they need. They care that you understand their goals and can chart a practical path forward. The legal analysis comes after you understand the real problem, not before. This means asking questions law school doesn't emphasize. What does success look like for this client? What are their constraints? Money, time, relationships? What risks can they tolerate? Every legal action creates reactions. File a motion and opposing counsel responds. Send a demand letter and you've shaped the negotiation before it starts. Recommend a contract term and you've locked your client into certain obligations. This is chess, not checkers. Before you recommend anything, walk through what happens next. If we file this complaint, how does the defendant respond? If we make this argument, what's the counter-argument? What does that mean for our ultimate goal? Law school trains you to build the strongest possible legal argument. Practice requires you to anticipate the response and already have your counter-response ready. Sometimes the technically perfect legal move is strategically stupid. The lawyers who distinguish themselves aren't the ones with the best legal arguments. They're the ones who consistently make smart, strategic decisions. Not everything is equally important. Inexperienced lawyers treat every issue as equally significant. They write 30-page memos analyzing every angle. They fight every battle with the same intensity. Veteran lawyers have judgment. They can quickly assess what's important and what's noise. They know which arguments actually persuade judges and which waste everyone's time. They know which contract provisions need real negotiation and which are boilerplate. They know when to fight hard and when to let something go. When you're reading cases, pay attention to what actually mattered to the court. Most opinions discuss lots of issues, but the decision usually turns on one or two key points. Train yourself to identify those determinative issues. If you only had time to research one issue thoroughly, which would it be? If you could only make one argument to a judge, what would you say? That's the kind of prioritization that separates good lawyers from mediocre ones. Every legal situation involves leverage. Who has it, who doesn't, and how it might shift. Understanding leverage means understanding alternatives. In litigation, leverage comes from the strength of your case and the cost of continuing to fight. In transactions, leverage comes from having options. Who else can provide what this party needs? In negotiations, leverage comes from patience and the ability to walk away. Cases settle based on leverage, not just legal merits. Deals get done when both sides believe the agreement beats their alternatives. Start thinking this way now. When analyzing a case, don't just think about who should win on the merits. Think about who has leverage and why. Good lawyers are good writers. Great lawyers understand that every piece of communication serves a purpose beyond conveying information. When you write a brief, you're persuading a judge who has 30 other cases. When you draft a contract, you're allocating risk. When you email opposing counsel, you're shaping the negotiation. Before you write anything, ask, what am I trying to accomplish? What does my reader need to know or do? Law school teaches you to write like a professor, comprehensively, cautiously, with caveats. Practice requires clarity and conviction. Clients don't want 6 paragraphs of hedging before you get to your actual recommendation. Every sentence should serve your purpose. If it doesn't move your argument forward, cut it. Say what you mean. Be specific. The lawyers who get read and respected communicate strategically, not just correctly. Legal problems rarely have clear answers. Veteran lawyers have learned to work through ambiguity and make sound recommendations anyway. They think probabilistically, not, will we win this motion, but what's the likely range of outcomes and how should that inform our strategy? Not, is this enforceable, but what level of risk does this create and is that acceptable? This doesn't come naturally to law students used to questions with right answers, but practice is full of gray areas where you need to make recommendations based on incomplete information. Get comfortable saying, here's what we know, here's what's uncertain, here's my assessment, and here's my recommendation. Clients value lawyers who provide clear guidance despite ambiguity, not lawyers who hide behind uncertainty. Judges are people with preferences and limited patience. Opposing counsel have their own pressures. Clients have fears and constraints they don't always articulate. The same legal argument can succeed or fail based on how it's presented and to whom. The same negotiation can end in agreement or impasse based on understanding what the other side actually needs. When you're reading opinions, think about what persuaded that judge. When you're watching negotiations, notice what works and why. When talking with clients, listen for what they're not saying. You don't need to wait until you're practicing to develop these instincts. Apply strategic thinking to your academic work. When analyzing a case, think about what really mattered. When writing a memo, be ruthlessly clear. When considering a hypothetical, think about leverage and alternatives, not just rules. Seek out clinics and externships that force you to think beyond pure legal analysis. Talk to practicing lawyers about how they approach problems. Ask how they decide what matters, how they think about strategy, how they handle uncertainty. Most lawyers are competent at legal analysis. What separates the ones who excel is strategic thinking, sound judgment, and the ability to see beyond legal issues to the real problems that need solving. Start thinking that way now, and you'll hit the ground running. Level up your legal reasoning with practitioners' strategy notes, expert-written insights designed to help you think several steps ahead, just like seasoned California attorneys do.